In this next segment, we'll talk about the basic rights of a victim in the military justice system. The rights that you see here on this slide are consistent with and very similar to the ones that you might see certainly in the federal system under the Crime Victims' Rights Act, but also should be familiar to those who are active in the space. So they're the common rights that you would expect all victims to be provided in the military. They are provided by Operation Article 6B, which is an article under the Uniform Code of Military Justice and mandated by federal law. And they include the right to not be excluded from proceedings, the right to be reasonably heard, the right to confer with the government, to speak to the government and to advocate the victim's position, the right to reasonable, accurate, and timely notice, to protection from the accused, and from proceedings free from unreasonable delay. The victim also has a right to restitution as provided in the law, although as we will discuss, that is a right in theory, not in reality. And then finally, the right to be treated with fairness and with respect for the dignity and privacy of the victim. So what are these rights? The first is the right not to be excluded. And the rule is pretty straightforward. Exclusion of the victim from a pretrial or court-martial is not allowed unless there is clear and convincing evidence that the victim's testimony would be materially altered if the victim heard other testimony. In practicality, what this means is that the victim has a right to be present for virtually every aspect of the pretrial and trial process. The only real exceptions would be the privilege or right that was not specific to the victim, in which case the victim would not be there because it would not be their privilege. Those are few and far between. So it's, in terms of the practice tips, this is a right that has been afforded. The courts are aware of, the courts will enforce. Typically, prosecutors can get over the question of whether or not a victim's testimony is materially altered if the victim testifies first, but the victims don't always testify first, and they're not required to do so in order to exercise their right not to be excluded. Ultimately, at the end of the day, whether or not a victim chooses to participate is a personal choice of the victim. It is not the government's, it's not the judges, it's not defense counsel. Some victims very much want to see and hear every aspect of the pretrial and trial process. Other victims want to get in and out of the courtroom as quickly as possible. And there are many iterations in between, and sometimes a victim's choices change over time. Your role as a victim's legal counsel is to help enforce whatever that victim chooses to the best of your ability. The right to be heard. The right to be heard is not exclusive of a victim. The right to be heard, though, is paramount to the enforcement of the victim's rights. In many of the circumstances in which the victim is asked their opinion, they do not have an absolute right to determine the outcome. A victim cannot require a prosecution move forward. A victim cannot require a particular sentence. A victim cannot require that charges not be dropped. But what a victim does have is a right to be heard on those topics. And that hearing and through counsel is really an important aspect of crime victims broadly, not just in the military and not just related to sexual assault. The right to confer affords the victim a right to speak to the government, meaning the prosecutor, regarding her or his views regarding pretrial confinement, the Article 32 preliminary hearing, the court-martial itself, any clemency or parole proceeding when a case is not referred to court-martial, a discharge in lieu of court-martial, meaning essentially a non-criminal administrative disposition of the case, and whether or not the victim wants to proceed in a civilian courtroom or through the military justice system. The right to notice. If you have a right to be heard, you must also have a right to know and be provided with accurate and timely information to be able to effectuate that purpose, both the right to confer with the government and the right to be heard on issues that directly and specifically impact the victim's rights. The right to reasonable, accurate, and timely notice occurs through the pretrial confinement phase, Article 32, court-martial, release, public clemency, or parole proceedings. And the military must ensure that the SBC, or Victims Legal Counsel, is, quote, provided prompt and adequate notice of the scheduling of any hearing, trial, or other proceeding. Now, significantly, the military justice system does not have the functional equivalent of PACER or of an online docketing system that allows counsel to be able to ascertain what's been filed in the matter. Instead, filings largely occur over email to the judge and the parties, and it is up to the judge and the parties to ensure that the victim's legal counsel receives adequate and timely notice. Typically, the court does this through either a requirement that the VLC be CC'd on particular communications, or through the provision of that information indirectly by the prosecutor, meaning the prosecutor receives a filing or a piece of information and then funnels that information to the victim's legal counsel. Now, as a practice tip, it's important to note that nothing stops you as a victim's legal counsel from asking that all materials in the case, all publicly available, non-sealed materials be provided to you, and not limited to the types of rape shield and psychotherapy motions that are common in the military. What I tell prosecutors or ask courts who I appear before and victims that I represent is that I want to have every piece of paper filed in the case, because I don't know when the victim's rights are going to be implicated. And only I can determine that as her counsel when I have an opportunity to review those materials. So whenever practicable, it is, I think, a good practice tip for victims legal counsel to seek to obtain access to all of the information that's been filed in the case, including all of the discovery motions that have been filed, all of the motions to dismiss as a matter of law, and even any unique issues that directly impact the defendant with limited victims legal counsel rights involved are still potentially important. For example, a motion to exclude the testimony of the defendant because it was coerced does not by itself directly implicate a victim's rights. However, the resolution of that motion, a determination that that statement, for example, is excluded, could have a material impact on whether or not there is a guilt determination. And that information is certainly something that your client would want to know. The right to reasonable protection is perhaps evident, and most specifically evident, in the military's use of safety transfers and safety planning. Those who are active duty soldiers, sailors, and Marines do have an opportunity to seek military protective orders and even to be transferred off of base because they fear for their physical safety. In addition, they have the right to something that's called an expedited transfer. An expedited transfer doesn't have to be for safety reasons. The concept of that and the reason for the creation of the expedited transfer process was to give the victims space and access to adequate support following a sexual assault, to ensure that the victim has those resources and is able to move forward, hopefully so that they can both be supported by the military, continue to want to serve their country and be able to serve their country effectively, and also provide them some measure of comfort that they will not run into their assailants. In addition to the safety planning and expedited transfer process, there is also civilian protective orders that can be employed. Certainly, you're not limited as a victim's legal counsel to only proceeding in the military, and the civilian protective orders are an avenue. The civilian protective orders have positives and downsides, and beyond the scope of this particular segment, other than to note a military protective order does not require a judge. It's issued by the commander of the defendant, and with adequate information, military protective orders can be implemented quickly and without need for an evidentiary hearing. Whereas typically, civilian protective orders, at least longer-term civilian protective orders, require an opportunity for the defendant to respond and the potential for the admission of evidence, all during a potential criminal investigation, things that you would want to speak to your client about in advance of seeking them. Other additional rights to reasonable protection include media and what I'll call gag orders. It is common for the military media to report on sexual assault cases. It is uncommon for there to be a large civilian presence in military criminal investigations or criminal prosecutions, unless the cases are of particularly noteworthy media attention, high-ranking officers, some other reason that the military might be paying, rather that the media might be paying particular attention. That said, there is an opportunity and there are ethical rules that prohibit counsel from speaking regarding the facts of a particular matter, and it may be in certain circumstances that civilian defense counsel may seek to avail themselves of media outlets to attempt to spin a story in support of their client. And it's noteworthy to know that one of the things a victim's legal counsel can do is to seek to prevent that from happening, at least with respect to commenting on the nature and veracity of the evidence in the case. And then finally, there are also trial protections, travel arrangements that are made by the military, where the military will pay for the witness, the victim and witnesses to come to trial. Those are things that from a practical standpoint, you'll want to be aware of to take into account the impact of the victim potentially on base, or the victim or her family having unintended interactions with members of the defendant's family are things you want to take into account during the pretrial and trial process in terms of accommodations. The court also typically will provide accommodations for counsel and the victim for them to have a private space to both to be at during trial and to confer with each other. It's extremely common. And then support personnel. I do not recommend that any victim's legal counsel go to a court martial without having somebody who's able to be with, sit with, advocate for the victim whenever possible outside of the courtroom. Meaning, when you're the VLC, if you are the one who is there to protect the victim's rights, your focus really should be on what's happening in the courtroom, what's happening with the judge, what's happening with the evidence. And someone else should really be there to ensure that the victim is receiving both reasonable protection from the accused, but also the emotional support, connection, interactions, and counseling that she or he will need to go through the difficult and arduous journey of a court martial. Next, there is the right to proceedings free from unreasonable delay. A victim has this right, and what exactly it means and the context of what it means remains uncertain in the case law. What we know it does not mean is that a victim can overcome a defendant's due process rights to adequate time to prepare for trial, nor does it mean that if there is a delay, that delay automatically is unreasonable. What it does mean is that the victim, the way I think of it, is that when there is a delay, for whatever reason, it does afford the victim an opportunity to encourage the court at a minimum to move the proceeding along as quickly and efficiently as possible, consistent with the defendant's due process rights. And this is important because the reality currently on the ground in 2021 is that investigations take too long. They can take anywhere from 6 months to a year, which is common. In complicated cases, they can take even longer. And then trial, depending on the nature of the case, from the time that the investigation concludes till you actually get a trial, is often 4 to 6 months. And then the turnaround of trial is typically another 6. 2 years from the time of reporting to the time of an actual court martial. So a very long and extended period of time, aiding to the challenges and difficulties that victims experience in coming forward and sustaining the emotional courage necessary throughout that period of time to continue to pursue and advocate for themselves, to stand up for their truth, and to ensure that justice is done to the best of their ability. All of those things come into play given the length and duration of the pretrial investigation and trial process. And throughout that, opportunities to advocate that things move more quickly or more efficiently because of the right to a proceedings free from unreasonable delay is an important advocacy point for all victims' legal counsel to consider. There is also technically a right to restitution. The law says that the right to receive restitution as, quote, provided in the law. However, the reality is that in the military, the law does not provide a mechanism for restitution. There is not a mandatory Crime Victims Restitution Act that mandates that certain monies be paid to a victim in restitution for the crime. So the reality on the ground today is that unless those monies are a part of a plea agreement itself, it is unlikely, if not impossible, that a victim will receive any restitution in a military proceeding. The last right, which I'll call the right to privacy here, is the right to be treated with fairness and with respect for the dignity and privacy of the victim. And we use Article 6B offensively whenever possible. And what I mean by that is it's not just a defensive right to say, I have a right to privacy. But whenever your client's right to privacy is potentially at play, Article 6B, at the minimum, affords you the opportunity to stand up and make an argument. And there are multiple situations throughout the proceeding, throughout the pretrial and trial proceeding, where an Article 6B right might be implicated. They can occur very early on in the process when the victim is being, and when the investigation is taking place and the military asks for the victim's phone. Article 6B applies there. The victim has a right to refuse to provide her phone. The victim has a right to refuse to provide the information on that phone that doesn't have anything to do with the sexual assault, and even to refuse to provide that information if it does have anything to do with the sexual assault, if it doesn't trigger a specific right of the defendant. That Article 6B right we see in multiple contexts. For example, we can see it invoked in the question of medical records. Active duty soldiers, sailors, and Marines do not have the same privacy expectations as civilians. Active duty soldiers, sailors, and Marines go for medical all the time. They have their initial interviews and their initial medical diagnoses when they enter the service. They have periodic fitness reports. Their expectation of privacy is diminished. But when they are a victim of a crime, they get a new right, an Article 6B right to privacy. And so just because, for example, the law does not recognize a medical privilege in the military does not mean that a crime victim does not have an Article 6B right to privacy that implicates those medical issues. And we have been successful in arguing that Article 6B should extend at least partially to the protection of non-essential medical information in a victim's files. It's also helpful to use Article 6B whenever there is any additional attempts to seek records or information that are not otherwise governed by a privilege, including information that may not be governed by, for example, the psychotherapy privilege, but necessarily are private in nature, including personally identifiable information or extraneous family information that does not have anything to do with the underlying offense.